All right, so I want Claudia. We need Peterman. We need Kate.
Yes.
Lori Putt.
Ben Gower.
Morning, Judge.
Are you? Is this on Scott?
No, it's on Ben Gower.
Ben Gower.
Ben Gower, yep.
And then there's Maria Guerrero. Yeah, Aguilar, both from Lifesaver.
We are going to call Miss Guerrero second. If you want to leave her in the waiting room,
Okay.
that's fine.
Do we need Molly Thompson?
Not yet.
Is your client somewhere?
Me? He's not called in?
I don't see him yet. Roundtree, is that somebody?
That's the second one.
Oh. Yeah, we have two hearings. I'm trying to figure out who's with what.
Let me find out Roundtree.
I think we have everybody for this hearing other than the defendant.
Yeah, that Roundtree is for the second hearing.
Okay. Trying to find this guy. There he is. All right. Wait for Hunter to come back.
I'm here. Is Gower on there?
Yes, he's here.
Okay, good. I was just texting you, Ben.
All right.
This is 003-85006-2019. State's first amended motion to hold bond insufficient. The state made to make an opening statement. Call your first witness.
State waives opening and calls Lori Putt.
Okay. Ms. Putt, if you'd raise your right hand to be sworn. You swear or affirm testimony about to give be the truth, the whole truth, nothing but truth, so help you God.
I do.
All right.
Miss Putt, will you state and spell your name for the record, please?
My name is Lori Putt, LauriPutt.
And how are you employed?
I am a caseworker with the pretrial supervision unit at Collin County Community Supervision and Corrections Department.
How long have you held that position?
2.5 years.
Okay, and what are some of the duties that you do as a pretrial bond caseworker?
As a pretrial caseworker, I monitor ignition interlock device and deep lung device reports for my clients. I have them come in for random urinalysis and I check those findings. I make sure that they are reporting once a month like they're requested to, that their payments are on time, and that they are basically adhering to the conditions set before them by the court.
Is one of your clients that you supervise Ben Gower?
That is correct.
Okay. For what offense is he on pretrial supervision?
Right now, he is on for driving while intoxicated with a blood alcohol level greater than 0.15.
What are some of the conditions of his bond?
His conditions are he is not allowed, or he's not to drive a vehicle unless it's equipped with a properly functioning ignition interlock device. If he is not going to be driving, he's going to be given, or he's going to obtain a portable or an in-home device. He is not allowed to have any alcohol, marijuana, dangerous drugs, or any substance prohibited by the Texas Controlled Substances Act. He's required to report once a month to CSCD. He's required to pay $45 in supervision fees. He cannot have any new offenses in the state of Texas or the United States. He cannot drive a vehicle without a valid driver's license. And he's required to report to us within 7 days of having his conditions signed.
Okay.
Just off the top of my head.
No, that was great. Are you aware if Mr. Gower has violated any of those conditions that you just laid out?
He has.
When were you first notified that he violated one of those conditions, and what condition was it?
I received a lifesaver report for his portable device, and the date of that report was January 26th. He had violations on his device for January 22nd. At 8:11 in the morning, he tested with a .058. At 8:41 in the morning, he tested with a .050. And then again, at 9:05, he tested with a .053. And I believe that that goes against the alcohol violation.
Okay. What do you do when LifeSafer sends you these reports? What do you do in response?
I contact the client to discuss any violations with them to see what's going on. I am required to submit a violation to the court, which I did.
Okay. Starting first, when you contacted Mr. Gower about these violations, what did he tell you?
I'm getting to my chronos if I may have just a moment.
Yes, and you can refer to those, just don't read directly from them, okay?
Perfect. Okay. On January 23rd, he submitted an email to me and told me that he had blown into his device and he had failed. When I asked him if he had been consuming alcohol, he did state that he did.
Is that a violation of one of his conditions to not
That
consume?
is correct.
Okay, you also mentioned that you submitted a notice of violation report. I'm going to share my screen and show you what's been submitted to the court as State's Exhibit 1. Ms. Putt, can you see that?
Yes, I can.
And can everyone else, the court, Judge Baxter, can you see it as well? Okay.
Yes.
Ms. Putt, I'm showing you State's Exhibit 1. Do you recognize this document?
I do.
And what is this document?
This is the copy of the notice of violation that I submitted on February 17th.
And this notice of violation, was this report made by you, I assume?
It was.
And do you have personal knowledge of the events recorded in this notice?
I do.
Was this notice made at or near the time of the events recorded therein?
It was made on February 17th.
Okay. And is it in the normal course of your business to draft these violations?
It is.
And is it in the normal course of your business to keep records of these in as part of your job?
It is.
Your Honor, we offer State's Exhibit 1 at this time.
Any
Is it
objection?
just that first page?
The first page, and then the whole document is also included.
If I could take the witness on board, Ira.
Yes.
Ma'am, did you you produced the first page, which you wrote out what he did wrong, right?
Correct.
Okay, but all the other stuff, you didn't produce any of that.
No, that was the violation or the report that was sent to me by LifeSaver.
Somebody that you don't know emailed that to you, and then you attached it here, right?
Yes.
Okay, no further questions, Judge. Judge, we have no objection to the part that she put in, but anything prepared by somebody else we'd object to.
The objection sustained. The first page will come in.
Okay, thank you, Judge. And again, Ms. Putt, this first page, does that document those initial violations for the alcohol?
Correct.
Okay. After the January violations, were you notified of any other violations of his conditions?
I was.
And when were you notified next?
He submitted a web report on July 8th indicating he got a traffic violation and received 2 tickets for being in an accident. I'm sorry.
No, go ahead. Was he supposed to be driving while on his pretrial supervision?
If he had obtained an ignition interlock device in his vehicle, he would be able to drive. However, he did
Okay, go ahead.
I'm sorry. He did sign a waiver stating that he was not going to be driving when he came through initial orientation, and he was required to obtain a portable or an in-home device.
Okay. After you were notified of this violation, what did you do? Did you draft another notice of violation report?
Yes, I did. I'm sorry. I was looking to make sure to see if I had contacted him or not.
Oh, okay.
That's
Now this notice of violation report, I'm again going to share my screen, showing you State's Exhibit 2. Ms. Putt, can you see this document?
yes, I can.
And it's actually 4 pages. So will you describe what all is included in State's Exhibit 2?
Yes, the first page is the notice of violation that I drafted,
Okay.
explaining that he had let me know that he had gotten the tickets when he was in an accident.
Okay.
The second page is the use of alcohol testing devices that he signed on October 9th, 2019, when he was in orientation, stating he would not be driving, and it was notarized by my supervisor, Nicole M. Gross.
Okay.
The third page is the instructions and guidelines for the home or portable device. At the bottom of that, the very last one, number 18, states you may not operate any motor vehicle, and he signed that on October 9th of 2019 with Carmel Dean, who did the orientation class.
Okay. And then this last page?
The last page is the chrono where it shows the web report he submitted on July 15th, and where it says, have you had any police contact since your last report? He explained that he had gotten into a car accident while he was driving.
So this notice of violation report and the documents following it, were these records, are they made by you in the regular course of your business?
Yes.
Are they kept in the regular course of your business?
Yes.
And do these documents contain information that was generated by someone with personal knowledge of the events recorded therein?
Yes.
Your Honor, we offer State's Exhibit 2.
I think you're muted.
No objection.
There you go. State 2 is admitted.
Okay, Ms. Putt. So from your time supervising Mr. Gower, how many violations are you personally aware of?
The one that he had in January, and then the one that he had in July.
Okay. We pass the witness.
Any questions?
Ma'am, with all these violations, this is the first time we've been before the judge though, right?
The first time I've been before the judge, yes.
Okay, nothing further.
Do you have any further questions?
Nothing further from the state. May this witness be excused?
Yes. Any objection from the defense?
No.
Good to go. You're good to go. Thank you. Call your next witness.
The state calls Maria, is it Guerrero or Aguilar? What's your,
Guerrero recently got married, so it changed. That's on transition.
okay, we call Maria Guerrero.
Would raise your right hand and be sworn. Do you swear or affirm testimony about to give you the truth, the whole truth, nothing but the truth, so help you God?
Yes.
All right.
Ms. Guerrero, will you please state and spell your name for the record, please?
Maria Guerrero, Guerrero.
How are you employed?
through Lifesaver Alcohol Specialist Monitoring for 6 years.
For 6 years. What are your duties as a in that position?
Log interpretation, portable training, as well as training centers, probation officers, and courts as well on how to use a portable device.
And how are you qualified to hold your position?
I was hired 6 years ago, and I started with ignition and log interpretations.
And do you receive on-the-job training, or how do you learn how to do what you do?
On-the-job training.
Okay. Are you familiar with how portable alcohol monitoring devices work?
Yes, we do our training on those.
Okay. Will you explain that briefly, how these devices operate?
Yes, so the defendant will submit a breath sample according to their testing windows, whether if it's prompt or not prompt or client initiated. If it's a fail, if it's a warning or fail, the defendant has to test, and then we'll send those notifications over to the probation officer.
Okay. Do you know if a Mr. Ben Gower uses a portable alcohol monitoring device issued by Lifesaver?
Yes,
Do you have records of his using this device?
yes.
Okay, I'm going to show you States Exhibit 3. Ms. Guerrero, can you see the document I'm showing?
Yes.
Okay. What is States Exhibit 3?
It's a client event summary.
Okay. And who is this for? What client?
Mr. Ben Gower.
Okay. Now, did you send me this document?
Yes,
Okay. Was this document made by someone with personal knowledge of the events recorded therein?
all of our data gets transferred, and then the reports get generated, so.
Okay. Are these reports generated in the regular course of your business?
Yes,
Are they kept in the regular course of your business?
yes,
Are these reports made at or near the time of the events recorded in these reports?
yes,
Your Honor, we offer States Exhibit 3, the client event summary.
No objection.
State 3 is admitted.
Okay, Ms. Guerrero, let's just walk through what do we see on the first page of this event summary?
The first page, which you're seeing, it's when the log began date, which is December the 1st, and it's run all the way through January 31st. Throughout that time frame, there were 177 tests that were taken. 15 were out of window, 19 were skipped, and there was a warning, which we call 0.02, 0.029, one warning, and there were 3 violations equal or greater than a 0.03.
Okay, and are you seeing that information below Mr. Gower's photo?
Yes, and we also show his testing windows as well.
Okay. Scrolling down, on December 4th of 2019 at approximately 6:04 p.m., what was reported on his device?
It's a violation refused. So during December, he was under the random settings, what we called. So between 5 a.m. and 8 a.m., the device will prompt him to test. He has 30 minutes to test during that time period. So that window started, he has 30 minutes, it closed, there was no test submitted.
Okay, just one second, my phone's ringing. Okay, so that was on December 4th. Going to the second page, December 5th, were there any other violations that you were aware of?
Same, he keeps on missing his random. So he has 30 minutes, it's initiated. It's a loud beeping noise that's coming from the deep lung device. So he
Okay,
has 30 minutes to submit a breath sample.
okay. And I'm actually gonna go to December 28th on page 5. Were there additional refused random tests on that date?
Yes, his testing window keeps on closing.
And were those violations continued on December 29th?
Yes,
Okay. Moving to January 20th on page 7 of States Exhibit 3. What happened on January 20th at 8 a.m.?
he had a 0.015 reading.
Is that in the warning range?
That's in the warning range, yes.
Okay. Then on January 22nd at 11:44 a.m., what occurred?
He had a .05 reading.
And then,
He initiated a self-test again at 8:41,
okay, and what was the BAC on that?
.05. And then he had abort flows. What that means is basically throughout the deep lung device, if you blow before or prior to the cutoff time, which is 10 seconds, it will give you the aborts.
Okay, and then that's at 9:05 a.m. What was the BAC then?
.05.
How do we know that these readings are accurate?
The device gets calibrated. He comes in on a monthly basis to calibrate the unit, and we calibrate the unit for him.
Okay. In your experience, in your 6 years of experience, are these reliable readings?
Yes.
Okay. Pass the witness.
Questions?
No, Judge.
Is this witness excused?
Yes,
Yes.
by the state.
All right, you're free to go. Thank you very much.
Thank you.
Call your next witness.
State has no further witnesses.
You rest.
We rest and close. Oh, sorry, Hunter, do you have anybody?
We got this guy named Ben Gower we'd like to call.
All right, if you would raise your right hand and be sworn. Can you hear us? Mr. Gower, can you hear us? I don't know if it's froze or what. Mr. Gower, can you hear us? Probably need to call him or something. It's not.
I'll call him right now.
Okay.
Although it looks like he's on his phone.
Can you hear us at all?
Hey, Ben, are you able to hear us on the call, or what's up? He hasn't heard a thing of this whole hearing, Judge. Hold on a second. He hasn't heard a thing this whole hearing, apparently.
That's great. Zoom's great when it works.
Hold on, Ben. I'm getting instructions from the judge.
Can he hear it all right now?
Are you able to hear the judge right now? I'm going to put you on speaker. He hung up. Hold on.
Hello?
Hey, Ben, can you hear me right now?
Yeah, I can.
Okay, Judge, talk for a second.
Yeah. What we'll do is just use the phone to give you audio, if that
Okay.
makes sense. All right.
Can you hear the judge?
Yeah.
Okay.
If you would raise your right hand and be sworn in. You swear or affirm testimony about to give me the truth, the whole truth, nothing but truth, so help you God.
I do.
All right.
Ben, so we've had a hearing, but apparently you haven't heard anything, which is obviously a gross violations of your rights to confront your own witnesses. But I'm going to give you the short version here because I really honestly don't think it matters. Basically, what's happened so far is that the state has put on some evidence that says you've been drinking and driving when obviously you know you're not allowed to. You know you had conditions of bond, right?
Yes.
And you know that you weren't supposed to be drinking any alcohol during this time. Is that right? And that during this time, you blew into the machine at least a few times, maybe even more than that. That you have drank alcohol, correct?
I know about the fail that I did, and I submitted it back in January, and I started going to AA meetings afterwards.
Okay. Are you a recovering alcoholic?
Yeah, that's why I started going to the meetings.
Okay. How long? What's your sobriety date?
It's back in
Okay. And so how often do you go to meetings?
A couple times a week.
Okay. Are you doing them live? Are you doing them Zoom? I don't even know how they're doing them these days.
At this point, it's mainly through a app called Hangout on my computer.
Okay. And so you have a sponsor and everything?
Yes.
Okay. Are you driving right now?
No. I did drive a couple months ago, and that's when I got in the accident. I haven't been driving since. I've been Ubering ever since.
Okay. So you know the judge can do nothing at all. He can modify the terms of your bond, or he can just straight up put you in jail while the rest of this case is pending. We've discussed that, right?
Yes.
You know, he also has some other options about maybe giving you a new substance abuse evaluation or requiring an ankle monitor or just kind of continuing with the treatment path that you're on now. Is there anything that you think the judge should know before he makes his decision?
No, I think he knows everything.
I mean, you're admitting to what you did here. You're not saying it was, you know, hand wash or mouthwash or anything like that, right?
Right.
Okay. I'll pass the witness, Judge.
Any questions?
Yes, Mr. Gower, can you hear me?
Yes.
Okay. Were you arrested on September 10th of 2019?
I believe so. I don't know off the top of my head.
Were you, how about just in the month of September of 2019? Were you arrested?
I know that I was arrested about a year ago for a DWI. So
Okay.
it might have been September 19th. I don't know the exact date.
Okay, so while you were on bond for your first DWI, you were arrested again for a DWI. Is that correct?
That is correct.
Do you know the blood results of that DWI?
I'm sorry. I'm going to object, Judge. I'm not going to let him answer questions about a pending case.
Sustained.
We pass the witness.
Anything else?
And at that time, you got a new bond from whoever the magistrate or the judge was, right, Ben?
Yes.
So they obviously knew that you already had one before that, correct?
Yes.
Okay, nothing further.
Anything else from the state?
Nothing further from the state.
Defense, rest and close?
We'd rest and close.
State closes
rest and
as
close.
well. Yes, Your Honor.
Any argument?
Do you want me to go first, Judge?
Yes.
Okay.
Yes.
Judge, I appreciate Mr. Gower's, admitting to what he's done, and that I do appreciate that he's going to AA, it sounds like. However, we have multiple violations here. He is going to be a continued risk to the community if he continues driving. We have refusals and missed blows, high BAC readings. He's admitted to consuming alcohol. He's also driven while he wasn't supposed to, and he was arrested for another DWI. Just given the facts of these multiple violations, we're going to ask that you hold his bond insufficient, or in the alternative, at least add a scram monitor. The portable one is not working. He's not using it consistently. So we would ask for more stringent regulations.
Anything else from the defense? Any argument?
Judge, we'll leave it to you. I mean, the judge at the time obviously already knew about this. It's been a year. I mean, that's just kind of COVID that made this hearing take so long to get to, but he seems to be doing right. We're pushing forward with his cases, and I probably anticipate an ending coming up soon if we can do it, but we'll leave it up to the court.
Does he need to drive right now? Is he driving at all?
He's Ubering everywhere right now.
Okay.
Right.
Here's what I'm gonna do. I'm gonna add scram as a condition of probation. I'm not gonna put him in jail, but I'm gonna add scram as a condition. I want him to go to AA 5 times a week, and then no driving I think that's already a condition, but that's gonna be added as a condition of his bond. Okay.
Okay, Judge. Thank you.
You got all that?
Yes, thank you, Judge.
Right.
Does he need
Good
to go
luck.
meet with? Does he need to go meet with community supervision again?
Yes, to get the scram device put on.
Or okay. Can you have 7 days to get in there?
7 days, and then obviously the faster you take care of the case, it
Yeah,
could
yeah.
be- yeah. Anyway, all right. Good luck.
All right, thanks, Ben. I'll give you a call.
See you later.
Bye.
Mr. Gower, you can go. There you go. Do we have everybody we need for this one? We have the state who's muted.
Yes, Your Honor. Everyone for the state is here.
Argus. All right.
And you should have Josh Roundtree and Amy, but those are,
We don't have Amy.
she may not be
Okay. All right. This is, let me get back on here. This is 0038311102020 State Tex versus Mark Allen Scott. And I think we're here on a state's motion to hold bond insufficient.
Yes, Your Honor.
All right. First amended motion to declare bond insufficient. At the state meeting, make an opening statement, required first witness.
State will call Detective Joshua Roundtree.
If you would raise your right hand and be sworn. You swear or affirm testimony about to give me the truth, the whole truth, nothing but truth, so help you God.
Yes.
All right.
Good morning, Detective Roundtree. Will you introduce yourself to the court and spell your name for the court reporter?
It's Detective Joshua Roundtree, JOSHUA ROUNTREE.
Detective, how are you currently employed?
Currently employed with the Wiley Police Department.
Are you a certified peace officer with the state of Texas?
Yes, ma'am.
And what is your current role in the Wiley Police Department?
My current role is I'm the Capers Detective for the Criminal Investigations Division.
Okay. And what is the Capers Detective?
I focus primarily on crimes against persons, for example, assaults, robberies, domestic violence.
Okay. And out of all the cases that you have, would you say that domestic violence cases are a lot or a few of your caseload?
I would say majority, probably around 90%.
I want to turn your attention to an incident on February 8th of 2020. Are you familiar with an incident on that day in Wiley, Texas involving Mark Scott?
Yes, ma'am.
And what was your role in that incident?
I was a detective assigned to do a follow-up investigation.
Okay. And was Mark Scott arrested as a result of the incident on February 8th, 2020?
Yes, ma'am.
And what was he arrested for?
He was arrested for assault, bodily injury, family member.
Okay. And who was the victim in that case?
His wife, Amy Scott.
Detective Roundtree, do you see Mark Scott in this Zoom hearing today?
I do.
Can you identify him by an article of clothing that he's wearing?
Black t-shirt and glasses.
Your Honor, may the record reflect that the detective has identified the defendant.
The record should reflect that.
At this time, state would offer the certified conditions of bond that was labeled State's Exhibit 1 that were the conditions from this offense, the February 8th, 2020.
Any objection?
I have no objection to that.
States one's admitted.
Detective, I'd now turn your attention to May of 2020. Are you also familiar with an incident that occurred on May 18th, 2020 in Wiley, Texas?
Yeah,
And did that incident involve this defendant?
it did.
What was your role in that incident?
I was the lead investigator for that incident.
And at the conclusion of your investigation into that incident, did you determine that there was probable cause to arrest this defendant? Sorry, can you say that one more time?
Yes.
Okay, and what was he arrested for?
I obtained an arrest warrant for continuous family violence against the family.
Okay. And why was he arrested for continuous family violence?
Because he committed assault against a family member with that happened 2 or more times within the last 12 months.
Okay, and have you submitted that case to the Collin County DA's office already?
It does show to be the case built and sent. Yes, ma'am.
And finally, I want to turn your attention to August. Are you also familiar with an incident that was reported on August 12th of 2020 involving this defendant?
Yes, ma'am.
Okay, and what was your role in that incident?
Again, as the lead investigator.
Okay. And at the conclusion of your investigation, did you believe that there was probable cause to arrest the defendant?
Yes, ma'am.
And what was he arrested for in this instance?
I've obtained an arrest warrant for violation of bond and/or protective order.
Okay. And specifically, what condition of bond was he violating?
He had a condition on his bond that stated that he could not have any contact whatsoever with any Scott.
And the contact that he was having, was that calls, text, or both, or in person?
Both. Text messages and phone calls.
Detective Roundtree, in your training and experience, is there anything concerning to you about this defendant's behavior?
Yes, ma'am.
Can you explain a little bit about that?
Since I've been working with the Wiley Police Department, and mainly since I've been assigned as the Capers detective, the Wiley Police Department has been to that residence several times. The call volume or calls for service has increased with time, and every protective measure that we have put in place to prevent further violence in some way so far has been violated.
Thank you. Your Honor, at this time, I'd ask that you take judicial notice of the bond amounts in this case for this defendant. For the assault family violence case in February, the bond amount was $2,500. The continuous family violence case, the bond amount was $3,500. And for the violation of bond or protective order, it was a $2,500 bond.
Okay.
State will pass the witness.
Any questions?
No questions.
Is this witness released and excused?
By the state.
By defense? Yep, you're free to go. Thank you very much. Call your next witness.
State has no further witnesses, Judge.
Does defense have any witnesses?
Well, at this point, I move to dismiss this. There's no indication that Mr. Scott committed any violations of the bond conditions, only that he was arrested for supposedly having some type of assault involving a family member, and that he had violated some kind of bond conditions about calling and phoning without any specifics about who that was or when that was. So we have no actual facts here. So I move to dismiss it because there have been no indications of any evidence of a violation of any bond conditions here.
Well, I think one of the conditions of bond is that you not commit any new offenses against the state of Texas.
All we have is that he was arrested. There were no facts. There's nothing put behind it other than there was an arrest. And it isn't even an arrest of who. Oh, excuse me. There was no indication that he was arrested for committing any violation against the complaining witness in your case.
Well, I understand that, but there's one of the conditions of bond is not to be alleged to have committed any new offenses against this state or any other state. That's one of the conditions of bond.
Yes, and if he is simply arrested and we have no facts behind the arrest that shows that he committed an offense, then we have no evidence of actually committing an offense. He simply was arrested for some offense, but no indication of any facts behind it that would support the reason for an arrest. And
I mean, I think the detective testified that he believed he did commit. So I think they've met that issue somewhat anyway. I understand what you're saying though, but your
right.
motion to dismiss is denied at this point.
All right. At this point, I would like to call Mr. Scott.
Okay, if you'd unmute and raise your right hand. You swear or affirm testimony about to give me the truth, the whole truth, nothing but truth, so help you God. You'll need to unmute. You're still not unmuted. It's a little red button.
Wait a minute. I think it was unmuted for 1 second.
There you go.
I think I got it.
All right.
Okay. All right. Thank you. Now, Mr. Scott, I'm not going to go into the facts behind the arrest of May 18th. Suffice it to say, you did not commit any criminal offense concerning assault, family violence on May 18th of this year. Is that correct?
Yes, sir.
Okay. Now, with respect to being with Amy Scott, you were aware with respect to your arrest on February 8th on this particular case, you had an emergency protective order, correct?
Yes, sir.
How long was that order in place?
61 days.
Okay. Now, were you aware that in addition to the expiring emergency protective order, you had a bond condition that said you were not allowed to have any contact with your wife?
No, sir, not at all. I thought the EPO, once it was over, everything was fine. And like I say, after that was done, and we started talking and decided, let's try again. And
Okay. So just so we understand it, with respect to your being back together with Amy Scott for some period of time, it was after the expiration of the emergency protective order. Is that right?
Yes, sir.
And you were not aware that there was an unexpiring bond condition?
No, sir.
Okay. So you do admit, though, you and Amy did get together because the two of you wanted to give your marriage another try?
Yes, sir.
Okay. Now, with respect to any calling or texting of Amy Scott, did you at any point knowingly call or text Amy Scott after the bond conditions were put in place?
Yeah, I did once I knew about the bond, I never had any more contact with her.
Right. Well, I understand that, but there's allegations made that you called or texted Amy Scott at some point after the May incident, or at least after I'll go back this up. after the bond condition of no contact was put into place. So let me start this again, because I think I got this all confused. After the bond condition was put into place, involving no contact, we know that the two of you did try to work this out for a period of some weeks, and it did not work out. But there's also a claim that you called or texted her. You're aware that a claim has been made of that, correct?
Yes, sir.
Okay. Now, did you knowingly try to call or text Amy Scott, in addition to what we talked about, you're having actually gotten together with her?
No, sir.
Okay, now, I have submitted in advance Defense Exhibits 1 and 2, and which are things you sent me yesterday. You remember sending me 2 documents yesterday?
Yes, sir, I do.
You have a copy of them in front of you?
No, sir, I do not.
All right, well, I'm going to hold up this first one to the screen and tell me if you can see what that is.
It's a list of contacts that are in my phone.
Okay, now, in this list of contacts, there is a name of, another name of Amy, is there not?
Yes, sir, there is. My sister.
And what's her name?
Amy Wright is her name.
Okay. That's Exhibit 1. And I'll show you Exhibit 2. Do you recognize what that is?
Yes, sir.
What is that?
It's where I actually tried to contact her.
Well,
my sister.
that's on there as well, but that is a screenshot of what part of your phone?
The call that was made.
Well, does it also show her contact information?
Shows all my sister's information. Yes, sir.
Okay. I'd like to offer 1 and 2.
Any objections?
No objection, Your Honor. I don't see the relevance of his sister's contact information.
Well, Exhibit 1 and 2 are going to be admitted.
All right. Now, your sister Amy has the same first name as your wife Amy, correct?
Yes, sir.
And when you contact your sister, let's say you're going to text her, how do you go about doing that?
I just pushed the button and said, "Hey Siri, call."
Call Amy?
Yes, sir.
Or if it's a text, you say text Amy?
Yes, sir.
Now, up until you were suddenly contacted by the Wiley Commission, by the police, saying that you'd been calling or texting Scott, up until that point, did you have Amy Scott's contact information also in your phone?
Yes, sir, I did. Well, once I talked to the Wiley, I deleted everything about her out of my phone so it wouldn't happen again.
All right. And have you had calls and or texts with your sister, Amy Wright?
I don't have anything with, showing where we were texting back and forth. Usually I delete everything out of my phone.
No, I'm saying, well, has that happened, that the two of you call or text each other?
Yes, we have.
Okay. So, to any extent you might have in some way possibly contacted Amy Scott before you deleted her information, do you feel it's possible that she was receiving calls or texts intended for your sister, Amy Wright?
Yes, like I say, I've had no contact with Amy Scott since May, and I definitely didn't try to contact.
All right. So what I'm asking is that whether or not you believe it is possible that on some of your calls or texts involving your sister, Amy Wright, that Siri, when you said, "Hey Siri, text Amy," that the text went or the call went to Amy Scott.
Right.
Okay. Oh, one other thing. You have an ex-wife, correct?
Yes, sir.
What's her name?
Her name is Joanna
What's her last name?
Scott.
Scott. Has she had access to your phone over the last few months?
And anybody that's ever been at this house has had access to it.
Well, were you staying with her?
Yes, sir. I've been staying here. Yes, sir.
With your ex-wife, Joanna?
Yeah, yes, sir.
Okay. And during that time, has she had the ability to be able to use your phone?
That's not something that she would do. I mean,
Okay.
it's just not in her nature.
Okay. I have nothing further. That's witness.
Any questions?
Yes, briefly, Your Honor. Mr. Scott, you were arrested for assault family violence on February 8th, 2020, correct?
Yes, yes,
And you posted bond for that offense, correct?
yes, ma'am. I did.
A $2,500 bond?
Yes, yes, ma'am.
Okay, and as a result of posting that bond, you were given bond conditions, correct?
The only thing I knew was the EPO, that I couldn't contact her for 61 days. The judge made it clear whenever I went before the magistrate that for 61 days, I could not have any contact with it. Other than that, no one's told me anything else about bond conditions. Even some of the sheriffs that were there at the jail with paperwork, there were some boxes that weren't checked. And one of them that wasn't checked was saying that I could contact her. But like I say, I didn't have anything to do with her until that EPO was done.
Okay, so you're telling me that even though you've now posted bond a couple of different times in different offenses, that you're not aware that bond conditions exist for you?
I am now. I wasn't before. No, ma'am.
Okay.
I'm sorry. Go ahead.
Were you arrested in May of 2020 for a new offense for continuous family violence?
Yes, ma'am.
Okay. Are you aware that the state of Texas has alleged that you committed a new offense?
Yes, ma'am.
Okay. And were you again arrested this past weekend?
Yes, ma'am. For them saying that I texted her.
Okay. So are you aware that the state of Texas has also alleged that you've now committed a third offense?
If that's what they're saying, no, ma'am, I didn't realize that, but I guess that is true.
Okay. All right. No further questions, Your Honor.
Anything else from the defendant?
Nothing further, Your Honor.
You rest
Rest.
and close, both sides close.
Close.
Any argument?
Yes, Your Honor. Your Honor, this defendant is continuing to violate his bond conditions in multiple ways, starting with 2 new offenses, one of which is a felony, and both of which involve the same victim, Amy Scott. I don't believe that this defendant doesn't know that he is texting Amy Scott. On that contact list, there's only one Amy, so I'm not sure how he would be saying text Amy and it would be going to a different Amy than who he's intending to send it to. He's also continuously breaking the no contact provision of his bond conditions. And so the state's biggest concern is that this is going to continue to happen because the bond conditions that he has now clearly don't mean anything to him. He isn't changing his behavior. So for those reasons, and because defendants should not be allowed to post bond, be given conditions of bond, and then just claim they don't know anything about them, or they don't know what their conditions are, and out of concern for the safety of the victim, we would ask that the court either hold this defendant's bond insufficient or require him to wear an electronic monitoring device going forward.
Anything else from the
argument from the defendant?
Yes, Your Honor. We have no evidence whatsoever that Mr. Scott committed any offenses against Amy Scott, only that he was arrested for some things with no facts behind them whatsoever. He has admitted that he did have contact with her for a period of time in May of this year, after the 61-day EPO had expired, and that he was not aware of additional bond conditions. When we have seen nothing in State's Exhibit 1 that shows that Mr. Scott has signed off on these, or that he has been notified of these bond conditions. All we have is an order signed by Judge Missildine imposing some bond conditions. After he learned in May that he had bond conditions, he has had no contact with her. He has been arrested for allegedly calling and or texting her, but you haven't seen any calls or texts. He has said he did not call or text her, or if it happened, it would have been inadvertent because it would have involved a call or text to his sister who has the same name. So we have no indication that he has violated the terms and conditions of his bond, except for having been with Amy Scott, with Amy Scott's permission at a time when he was not aware those bond conditions existed. We feel that he has posted bonds and that the bond should stay as they are for now.
Anything else from the state?
Nothing from the state.
Well, I think he has violated bond conditions. I think I mean, there's new allegations of new offenses, and that's a violation. But when the judge set, or the magistrate set the amount of those bonds, they could have set those bond amounts at any amount. I'm assuming they considered the new charges as violations of previous charges. So I'm not going to change the bond amount based upon the new charges that he's had to post additional bonds for. As far as the contact with her, I think it's reasonable that he could have used Siri, and Siri could have done that to him. But I think he knows now not to ever contact Miss Scott again, and I'm assuming you won't do that. I think you've taken her name out of your phone to help you not do that. So I'm not going to change the bond conditions this time. So your bond's going to stay the same. Good luck. Thank y'all.
Thank you, Your Honor.